Hello everyone, welcome to the channel. Now we have reached to part 4 of the Constitution, which is Directive Principles of State Policy, DPSPs we say, Article 36. In this part, unless the context otherwise requires, the definition article, that the state has the same meaning as in part 3. If you remember earlier, part 3, state was in Article 12, the definition of state. Article 37, the application of the principles contained in this part is the provisions contained in this part shall not be enforceable by any court, but the principles therein laid down are nevertheless fundamental in the governance of the country, and it shall be the duty of the state to apply these principles in making laws. So the DPSP are not enforceable in any court. Therefore, the government cannot be compelled to implement them. Nevertheless, they are fundamental in the governance of any country, of our country especially, and it shall be the duty of the state to apply these principles in making laws. Distinction between fundamental rights and directive principles of state policy is that fundamental rights are that they constitute limitation upon the state action. They are already implemented by the constitution. Fundamental rights are enforceable by the courts. Whereas the directive principles of state policy, TPSPs, are instrument of instruction to the government. These directives are required to be implemented by the state. These directives are not enforceable by the court. Furthermore, in Article 38, the state shall strive to promote the welfare of the people by securing the protecting as effectively as it may a social order in which justice, social, economic, and political shall inform all the institutions of the national life. The title of this was State to Secure a Social Order for the Promotion of Welfare of the People. Secondly, the state shall in particular strive to minimize the inequalities in income and endeavor to eliminate inequalities in status, facilities, and opportunities, not only amongst individuals but also amongst groups of people residing in different areas or engaged in different vocations. Article 39, the certain principles of policy to be followed by the state. These are the most important principles. A. The state shall, in particular, direct its policy towards securing A. That the citizens, men and women equally, have the right to an adequate means of livelihood. B. That the ownership and control of the material resource of the community are so distributed as best to subserve the common good. C. That the operation of the economic system does not result in the concentration of wealth and means of production to the common detriment. D. That there is equal pay for equal work for both men and women. E. That the health and strength of the workers, men and women, and the tender age of children are not abused, and that citizens are not forced by economic necessity to enter vocations unsuited to their age or strength. F. That children are given opportunities to facilities opportunities and facilities to develop in a healthy manner and in conditions of freedom and dignity, and that childhood and youth are protected against exploitation and against moral and material abandonment. So about the common good in Kutch Jal Sankat Nivaran Samiti versus State of Gujarat, the Supreme Court stated that the expression common good means common good of the whole state, of a whole nation. About equal pay for equal work in Greh Kalyan Kendra Workers Union versus Union of India, AIR 1991, the Supreme Court has observed that denial of equal pay for equal work has become irrational classification within Article 14. In the state of Punjab and thus versus Jagjit Singh, AIR 2016, the Supreme Court said that in a welfare state, an employee engaged for the same work cannot be paid less than another who performs the same duties and responsibilities. Further, Supreme Court clarified principles of equal pay for equal work, and stated that in determining equality of functions and responsibility under the principle of equal pay for equal work, it is necessary to keep in mind that the duties of the two posts should be of equal sensitivity and also quantitatively similar. Equal pay for equal work, subclause D. In the state of Madhya Pradesh versus R.D. Sharma, 2020, the Supreme Court observed that the equation of post and determination of pay scales is the primary function of the executive and not the judiciary. It also held that equal pay, equal work is not a fundamental right. though it is a constitutional goal to be achieved by the government. About child labor, provision of Article 39E, 39F, 41 and 47. Article 30 41 and 47 can be pressed into the service of to make suitable provisions regarding child labor. Accordingly, in MC Mehta versus State of Tamil Nadu, AIR 1997, the Supreme Court has issued directions to the state to see that an adult member of the family whose child is in employment in a factory, mine, or hazardous employment gets employment anywhere in the lieu of the child. Further, Article 39A, we should read equal justice and free legal aid. The states shall secure that the operation of the legal system promotes justice on a basis of equal opportunity and shall in particular provide free legal aid by suitable legislation or schemes or in any other way to ensure that opportunities for securing justice are not denied to any citizen by reason of economic and other disabilities. This article was inserted by Section 8 of the Constitution, 42nd Amendment Act, 1976. Legal aid means an important impact of Article 39A read with Article 21 has been to reinforce the right of a person involved in criminal proceeding to a legal aid. This article has thus been used to interpret and even expand the right conferred by Section 304 of the Code of Criminal Procedure CRPC 1973. Legal Services Authorities Act 1987. This act was enacted to establish a nationwide uniform network for providing free and competent legal services to the weaker sections of the society. Every person who has to file or defend a case shall be entitled to legal services under this act if that person has annual income of not more than rupees 1 lakh. In the Supreme Court Legal Services Committee, the limit is rupees 1 lakh 25,000. This limitation is not applicable to scheduled castes, scheduled tribes, women and children, industrial workers, prisoners in jail, victims of communal violence, natural disasters, mentally disabled, etc. Article 40 about the organization of village panchayat. The state shall take steps to organize village panchayats and endow them with such powers and authority as may be necessary to enable them to function as units of self-government. As you know about the Pradhan, the Sarpanch, the Mukhya in villages, these are constituted by Article 40 for Constitution. It was Gandhian ideology whereby Gandhiji wanted democracy at grassroots level and decentralization of power at the lowest level. It was the Gandhian ideology whereby Gandhiji wanted democracy at a grassroots level and decentralization of power at the lowest level. Article 41, titled Right to Work, to Education, and to Public Assistance in certain cases. It reads as the state shall, within the limits of its economic capacity and development, make effective provision for securing the right to work, to education, and to public assistance in case of unemployment, old age, sickness, and disablement, and in other cases of undeserved want. In Sambhavna versus University of Delhi, AIR 2013, the Supreme Court has stated that it is the duty of the state to make effective provisions for securing inter alia the rights of the disabled and those suffering from other infirmities within the limits of economic capacity and development of the state under Article 41 of the Constitution of India. Thus, Article 42, titled Provision for Just and Humane Conditions of Work and Maternity Relief. Article 42 states that the state shall make provision for securing just and human conditions of work and for maternity relief. Maternity relief in India and the maternity benefits in India is mainly governed by the Maternity Benefit Act 1961 that applies to all shops and establishments with 10 or more employees. Employers are also required to inform women in writing or electronically about maternity benefit. The Act originally provided maternity benefit of 12 weeks, out of which up to 6 weeks could be claimed before delivery. In 2017, it was amended to extend the period to 26 weeks. Out of 26 weeks leaves, 8 weeks leave can be claimed before delivery. However, one can take entire leave after the delivery. The amendment of 2017 makes it mandatory for the establishment of more than 50 workers to establish crèches, and mother is entitled to visit it 4 times a day and 2 nursing breaks a day until child attains the age of 15 months. In MCD of Delhi versus female workers, Muster Roll AIA 2000 SC 1274. The maternity relief has been extended to a woman of muster roll employees working on a daily basis. However, enforcement of discipline and obedience by authority in the workplace has been held as no violation of Article 42. Article 43, the living wage for workers. The state shall endeavour to secure by suitable legislation or economic organization or in any other way to all workers, agricultural, industrial, or otherwise, work a living wage condition of work, ensuring a decent standard of life and full enjoyment of leisure and social and cultural opportunities. And in particular, the state shall endeavor to promote cottage industries on an individual or cooperative basis in rural areas. So in Navneet R. Kamani versus R. Kamani, AIR 1989, the Supreme Court went a step further and preferred the scheme for running the sick units by Kamani Employees Union to one presented by the mismanagement. It thus follows that workers, if left to their own, can forge ahead and can take steps to revitalize a sick industry. Article 43B. No, it was about Article 43A, which states that the state shall take steps by suitable legislation or in any other way to secure the participation of workers in the management of undertaking establishments or other organizations engaged in any industry. About this, it was said in Navneet R. Kamani versus R. Kamani, AIA 1989. The Supreme Court went a step further and preferred the scheme for running the sick units by Kamani Employees Union to the one presented by the management. It thus follows that workers, if left to their own, can forge ahead and can take steps to revitalize a sick industry. Article 43B, which is not stated in this PDF, I can talk to you about it. The promotion of cooperative societies. It was introduced in 2011, instituted in 2011, 43B. The state shall endeavor to promote voluntary formation, autonomous functioning, democratic control, and professional management of cooperative societies. Now, Article 44, the Uniform Civil Code for the citizens. Uniform Civil Code, the state shall endeavor to secure for the citizens a uniform code, civil code throughout the territory of India. It's the most controversial topic in the recent understandings. Article 44 of the Constitution of India requires the state to secure for the citizens of India a uniform civil code throughout the territory of India. India is a unique blend and merger of codified personal laws of Hindus, Muslims, Christians, Parsis, and many more religions. However, there exists no uniform family law in a single statutory book for all Indians, which is acceptable to all the religious communities coexisting in India. The question is not of minority protection or even of national unity. It is simply one of treating each human being with the dignity that he deserves, something which personal laws have so far failed to do. Article 44 is based on the concept that there is no necessary connection between religion and personal laws in a civilized society. Article 25 guarantees religious freedom, whereas Article 54 seeks to divest religion from social relations and personal laws. Marriage, succession, and life matters of a secular character cannot be brought within the guarantee enshrined under Article 25, 26, and 27. Goa is a shining example of an Indian state which has a uniform civil code applicable to all regardless of religion except while protecting certain limited rights. And now, currently, if you might know that Uttarakhand has also implemented Uniform Civil Code (UCC). The then Chief Justice Y.B. Chandrachud and Mohammad Ahmad Khan versus Shah Banu Begum case, AIR 1985, said that Article 44 of the Constitution has remained a dead letter. There is no evidence of any official activity for framing a common civil code for the country. A common civil code will help the cause of national integration by removing desperate. Let me read it out for you again. A common civil code will help the cause of national integration by removing disparate loyalties to laws which have conflicting ideologies. It is the state which is assigned with the duty of securing a uniform civil code for the citizens of the country, and unquestionably, it has the legislative competence to do so. Again, the Supreme Court in Sarla Mudgal versus Union of India, IIR 1995, questioned the government of India through the Prime Minister of the country to have a look at Article 44 of the Constitution of India and endeavor to secure for the citizens a uniform civil code throughout the territory of India. The Supreme Court in John Vallamatam versus Union of India AIA 2003 said that it is a matter of regret that Article 44 of the Constitution has not been given effect to. Parliament is still to step in for framing a common civil code in the country. Common civil code will help the cause of national integration by removing the contradictions based on ideologies. Article 45, which was substituted by the Constitution 86th Amendment Act 2002, Article 45 states that provision for free, no, it was the provision for free and compulsory education for children and provision for early childhood care and education below the age of 6 years. The state shall endeavor to provide early childhood care and education for all children until they complete the age of 6 years. So, the Article 45 given in the PDF talks about Article 45 is substituted and about after it, the Article 45 currently is provision for early childhood care and education to children below the age of 6 years. The state shall endeavor to provide early childhood care and education for all children until they complete the age of 6 years. Whereas earlier it was earlier the state shall endeavor to provide within a period of 10 years from the commencement of this constitution for free and compulsory education for all children until they complete the age of 14 years. Now, this has been done by the state in Article 51A. No, I don't remember exactly, but the state has provided for education for 14 years of children up to 14 years. Article 46, the promotion of educational and economic interests of scheduled castes, scheduled tribes, and other weaker sections. About it, the state shall promote with special care the educational and economic interests of the weaker sections of the people and in particular of the scheduled castes and scheduled tribes and shall protect them from social injustice and all forms of exploitation. The article is self-explanatory in its own. About it, the weaker about the weaker sections in Indra Sawhney versus Union of India, AR 1993, formerly known as the Mandal Commission case, the court laid down that the expression weaker sections of the people was wider than the expression backward classes of citizens or socially and educationally backward classes or scheduled castes and scheduled tribes. This expression included all sections of the society who were rendered weaker due to various causes, including poverty and natural and physical handicaps. Article 47, the duty of the state to raise the level of nutrition and the standard of living and to improve public health. The state shall regard the raising of the level of the nutrition and the standard of living of its people and the improvement of public health as among its primary duties, and in particular the state shall endeavor to bring about prohibition of the consumption except for medicinal purposes for intoxicating drinks and of drugs which are injurious to health. About this, the prohibition on liquor business in the state of Kerala versus Kandanath Distilleries, A 2003 13. The Supreme Court has held that a citizen has no fundamental right to trade or business in liquor. The state can prohibit completely trade or business in portable liquor, and the state can also create monopoly in itself for the trade or business in such liquor. Article 48, Organization of Agriculture and Animal Husbandry. The states shall endeavor to organize agriculture and animal husbandry on modern and scientific lines and shall, in particular, take steps for preserving and improving the breeds and prohibiting the slaughter of cows and calves and other milch and draught cattle. Article 58A, Protection and Improvement of Environment and Safeguarding of Forests and Wildlife. Article 48A states that the state shall endeavor to protect and improve the environment and to safeguard the forest and wildlife of the country. Article 49 states entitled the protection of monuments and places and objects of national importance. Article 49 is It shall be the obligation of the state to protect every monument or place of or object of artistic or historic interest declared by or under law made by Parliament to be of national importance from spoliation, disfigurement, destruction, removal, disposal, or export, as the case may be. Article 50, which is the most important DPSP for the judiciary, that the separation of judiciary from executive. Article 50 states that the state shall take steps to separate the judiciary from the executive in the public services of the state. Now comes the Article 51, promotion of international peace and security. About it, the state shall endeavor to A. Promote international peace and security, B. Maintain just and honorable relation between these nations, C. Foster respect for international law and treaty obligations in dealings of organized peoples with and one another, and D. Encourage settlement of international disputes by arbitration. So this was all about the Article 36 to 51. These were the DPSPs. This was the most interesting part for me. And thank you for watching till here. Thank you. You might have got a lot more ideas about DPSPs than earlier. Thank you.